this interview will focus on the emergency rule and if it will save lives, secure critical infrastructure like the president has established. And to have this conversation with us is the editor-in-chief of Supreme Court judgments of Supreme Court reports, Chief Barrister Tom Anyafulude. Thanks for joining us, Chief.
Thank you, Ngozi. Thank you for having me.
Okay, it's no longer news that the president announced emergency rule in Rivers State and already appointed and made sworn a sole administrator in that state. But update is on the points he made during the pronouncement, one of which is that the emergency rule will save life. I don't know if you agree with this or not. Chief,
now, the emergency rule is anchored on Section 305 of the 1999 Constitution. Now, that section gives the president power to not even to declare emergency rule, but to make a proclamation where a constitution provides procedure for doing a thing. That procedure must be rigidly followed. There is a difference in law between constitutional provision and the provision of rules. The constitutional provision must be rigidly adhered to. Now, under Section 305, the first step is to make an instrument. An instrument is an executive order. Now, I, President Bola Tinubu, make proclamation that a state of emergency, blah, blah, blah. That has to be published in a state gazette, and then transmitted to the National Assembly. And the National Assembly will debate the contents of that proclamation. And by 2/3 of members who approve the proclamation, it becomes law. So, in effect, you cannot say that a state of emergency has been declared until that is debated at the National Assembly. But in this case now, we saw a president who declared a state of emergency with immediate effect. Now appointed a sole administrator with immediate effect. So the president placed the cart before the horse. So there was no strict adherence to the Section 305. And to that extent, it is not proper. Now, we also saw a situation where a democratically elected governor and the House of Assembly were dismantled. So the question now is, and you did all this before the proclamation was debated in the House of National Assembly. So legally speaking, constitutionally, one, the president did not adhere to the procedure. Secondly, does he have the power to pull down democratic structures in Rivers State? In law,
okay,
where the Constitution makes provision, you cannot imply any other thing but to interpret it strictly. You can only remove a governor under Section 188 of the Constitution by impeachment. Now, if the Constitution intended there will be another way of disciplining a governor or removing a governor, the Constitution would have said under Section 188, subject to Section 305. Subject to Section 305. So the Constitution would have subjected Section 118 to Section 305. Rather, the Constitution said, under Section 305, it started saying, subject to the Constitution. Subject to the Constitution. That is the opening paragraph in Section 305. Subject to the Constitution. It means that Section 305, which gives emergency power, cannot go beyond the Constitution. It must be subjected to the Constitution. Tom Anyafulude is subordinate to. Tom Anyafulude is subordinate to. So Section 305 is subordinate to the Constitution, which includes Section 188 that it talks of removal of a governor. So the president has power to make proclamation. The president has power to publish instruments of that proclamation in the official gazette and then send it to the National Assembly. So he initiates the process of state of emergency, not that he declares it. That is the mistake people make. A state of emergency can only take place when it is voted, when it is sanctioned by 2/3 of each house of the National Assembly. And that is why the voting process is important, because it is a constitutional requirement, and it must be seen that everybody has adhered to the provision of the Constitution.
Okay. You have quoted the Constitution, and you've tried explaining what the Constitution says in emergency rule and declaration of emergency rule. But there's a part of that, the basis for declaration that I want us to handle, and that's the part that stated the conditions upon which an emergency rule should be instituted in a country or in a state. And that's one of the reasons, one of the conditions pointed to saving lives. And so I'd like us to look at the Rivers situation. Is the situation emergency enough for declaration of emergency rule?
You can only declare emergency rule when you have to restore peace and order that requires extraordinary measures. If the federal government can contain Boko Haram in Borno, if the federal government of Nigeria can contain the terrorist group now, ravaging Sokoto State, if they can contain those ones in Yobe, so what is in Rivers State that requires extraordinary measures? You have not tried, even if there is a threat to pipeline, the federal government can, dispatch security agents. And then, secondly, you can also declare a state of emergency in Rivers State without tampering with constitutional, democratic institutions like the governor or the House of Assembly. What it means, what does it mean, state of emergency? It means that you will suspend the operation of Section 4 of the Constitution, which deals with fundamental rights. The federal government can say, we are declaring state of emergency in Rivers State. It means that if anybody is seen around the pipeline, if anybody comes out at night, if anybody talks anyhow, you can now arrest without observing the fundamental rights of the person. You can detain without trial. You can detain without giving bail. You can restrict movement in order to ensure that there is peace and there is security. Extraordinary measure is something beyond the capacity or the capability of the police and the military. That is what it means. You can declare a state of emergency without touching the governor or even the House of Assembly. It means that you are going to suspend the Chapter 4 of the Constitution, and you can take extraordinary draconian measures. We don't respect human rights. You can just bungle people into prison. You can arrest. You can say don't come out. Don't use speech. Don't make any statements. All these things you do, and to ensure that there is no breakdown of law and order. So it's a misconception to feel that state of emergency can only be declared when you suspend the House of Assembly or you suspend the governor.
Okay. But just before the declaration of the state of emergency by the president on Rivers State, a pipeline was blown a night before. Do you think that could have been averted if emergency rule was in place before that night?
Now, was there any investigation? The pipeline was blown today, tomorrow you declare state of emergency. Now, was it investigated? Now, we are now coming to realize that it was not even a pipeline breaking.
Because of the agitation of the IYC, Ijo Youth Council, and some Ijo leaders, because of the utterances of the former governor of the state, who happens to be the FCT minister, it was looking like more of that was going to come, and then the president had to do what, if he had continued with investigation, probably more pipelines would have blown up, don't you think?
Now, you don't act on speculation. Remember that the governor of Rivers State is not the chief security officer. He is the chief security officer on paper. But in practical terms, the security of the state is strictly the responsibility of the commissioner of police and the military personnel there. So, it is not as serious as, it will not warrant the dissolution of democratic institution, because you are suspending the operation of the constitution. It's very serious. We are no longer in a military regime. We are in a civilian regime where the president is even under the constitution. This constitution is a grand norm. It is a supreme law, and everybody, including the institutions like the Supreme Court, we are all under the constitution. So, I agree that to some extent you have to take some steps. You have to be proactive, but proactiveness will have to be based on reasonable ground. After all, the same Wike said that it is not only Ijaw people that know how to break pipelines, that Ogoni people can also break pipelines. That one is a statement too that should require, that is supposed to be cautioned. Now, the pipeline that was broken was not in Ijaw land, it was in Ogoni land. And then, the statement by these Ijaw people, when they made this statement, did you invite any of them for interrogation? Did you invite them for interrogation and for further clarification on that security breach, the statements? So you don't just act speculatively. So based on law, it was premature and not substantial enough to declare a state of emergency.
Now, on the basis of residual knowledge of what emergency rules have been like, at least since 1999. At some point, I think in 2004, it was the then president Obasanjo that instituted a state of emergency in Ekiti State, I think, and then thereafter in 2006 in another state, and much later Goodluck Jonathan will declare a state of emergency in about 3 states in the north. With the hindsight now, do you think that security is actually guaranteed the next 6 months of this emergency rule in Rivers State?
Well, nobody can vouch for, but there was the fear of insecurity in Rivers State is speculative. In Rivers State, people are going about their normal duties. They are going about doing their things. Even in Ijo land where the threat was, done, nothing, there was no real situation to warrant declaration of emergency. Rather, it was even the minister that came to Calabari last week and was making provocative statements. He described the sitting governor as a boy. He described Supobara as a boy and was making statements and saying that the House of Assembly will do their constitutional duty. Now, let me even say this, that this issue of declaration of state of emergency is a face-saving strategy, because that impeachment would not have succeeded. I do not think that they would have crossed all the hurdles, especially the judicial hurdle, because you cannot impeach a governor without the concurrence of the judiciary. They were having problems with the chief judge, and that is why they accused the chief judge of certificate forgery. And then they dropped that. Now, let me tell you, if they were having it easy, why did they not go with the option of impeachment? Because if they had gone on with the option of impeachment, the members of the House of Assembly would not have lost their seats. And it is constitutional to impeach a governor. But they knew that they could not cross those hurdles. And then they now reverted to state of emergency, which is easier for them.
We're still looking at the security of lives and the infrastructure in Rivers State, looking to see if there's going to be absolute security, okay, something near that, because nothing is absolute really in Rivers State, given that a pipeline was already blown up. And I know that since this declaration, the Ijo Youth Council as an organization, as a body, has not really made any categorical statement since then. But that does not mean that they have nothing up their sleeves or that they are lying low. Nobody can affirm totally. But I need to actually establish that the former chief naval officer who is now the sole administrator of Rivers State, being a naval man, will actually abide by what we were told he was coming to do to ensure that there is security of lives and property and that peace is totally restored in Rivers State. Do you think that this will work this time around?
Nobody can actually say. But on paper, when you have now declared a state of emergency, it means that you are operating emergency rules. You are now suspending the operation of the Constitution. The operation, especially Chapter 4, which deals with fundamental rights. Hello?
You are on, Chief.
Which deals with fundamental rights. So, the state administrator will employ extraordinary measures, non-constitutional methods to ensure the enforcement of law and order. Like somebody may be arrested without trial. Somebody can be arrested without warrant of arrest. You can bubble into a person's house when it's based on suspicion, and then without even warrant of arrest or search warrant, and such little things. So the security agents will have more latitude to enforce law and order. That is the only thing I know. But whether there will be more guaranteed peace is what I cannot say. But they have more latitude, they have more power to enforce law and order and that those powers can be abused if they like.
Quite a number of persons in Nigeria have criticized the emergency rule. Does it mean that they are not looking at the same angle as the president, who thinks that this emergency rule is about the only option that is left for Rivers turmoil since close to 2 years now? Are there still people playing politics around all of this, or do they mean well in their criticism?
Apparently, emergency rule is not the only option. After all, is it not the same president that invited members of the House of Assembly of Rivers State to Abuja? And they held a closed door meeting for hours and came out and singing on his mandate we stand. So, what prevented the president from undertaking official visits to Rivers State? This type of thing is enough. Or we justify the president visiting Rivers State for an official visit, and then have closed door meeting with the House members, and the governor, or even invite them to Abuja. And at the end of the day, they will start singing on his mandate we stand, and the whole thing will resolve. So I do not think that the president did enough. And then I want to bring a dimension which everybody seems to ignore. The members of the Rivers State House of Assembly even did not comply with the decision of the Supreme Court.
How?
The Supreme Court said in the judgment, Fubara should go and represent the budget before the House of Assembly of Rivers State. Now, the House of Assembly of Rivers State, before that Supreme Court judgment, was polarized into the other man's
Jumbo
and Victor. So, the first step towards abiding by the order of the Supreme Court is to reconcile these two factions. In order to obey the order of the Supreme Court, you take steps to reconcile the factions. But the other people still said that the Jumbo's faction was suspended. The members were suspended. So you are not abiding by the Supreme Court, but because for Fubara to present a budget, it presupposes that he will present it before a united House of Assembly, where there will be no longer any division. So there was still division. But the governor continued even dealing with the Martin faction, the other 27 members, ignoring his own pro-Fubara faction. And still, they were not, satisfied. In fact, if the other group were properly advised, the members were properly advised, they would have gone to court, getting an injunction to stop the governor presenting a budget before just one group. Because the Supreme Court said the members of Rivers State House of Assembly. So the other group, Martin, the pro-weekend group, is not without fault. And this man made the effort to present the budget as directed by the Supreme Court. But to my mind, all these things were, pre-arranged. It has been decided that he will not present the budget, and that they are going to have they are going to declare a state of emergency. Otherwise, you as the president or whoever would have facilitated the reconciliation and give them order. You are the father of everybody. Try to call them back as you did in Lagos State. Try to make peace. Try to intervene physically. So he did it, and he did not do enough. Now, the other elders forum went to him. He asked them to go and make peace. When they left him, the next day, Mwike started insulting them, calling them names. Victor Atta, the governor. And then, the president heard this when he was insulting them, And then you did not give them opportunity to exhaust. They go all, that peaceful reconciliation, and then you declare the state of emergency. So he even slighted the Elders Forum of Rivers State.
And the Pandef too. Okay.
That is the Pandef.
Chief.
There's a proverb in Igbo which says that you cannot ask somebody to go and sell salt in the market, and then immediately you will, bring down rain, invoke rain, invocation, and then rain will start by beating the man you asked to go and sell salt. Because salt and water, they don't go together. The salt will just melt under the influence of, rain.
Now, looking at this situation, the whole hog, what does it mean for our 25-year-old democracy? What is the trend?
Hello?
Are you there, Chief?
Pardon? Yes?
Okay. I said, what does this situation mean for our 25-year-old democracy? Looking that we are moving towards 2027, which is just having 1 year gap, just after 2025, 2026 will be the heat. Does it look like a plan of a crab activity on River State? Lagos is also faced with a semblance of quagmire in the House of Assembly. There's also Kano State, and it's looking like someone wants these 3 states, because all is not well everywhere, but I'm particular about these 3 states. What does this situation mean for 2027
Nobody
election?
can win the presidency. Nobody can become president of Nigeria without winning Lagos, Rivers, Kano,
because of what?
Because of their strategic position, their economic position, their population.
Okay.
Now, this suspension of this emergency rule has both 2 angles, the legal angle and the political angle. Now, in terms of politics, this sole administrator will conduct local government election within his lifespan. And you know what that means. Whoever controls the local government controls the state. Whoever controls the local government system controls the structure of the state. So, I suspect that he will conduct the local government election, and definitely the first casualty will be the chairman of River State local government, whatever. He will go. The administrator will conduct local government election, and once he conducts it, your guess is as good as mine. And then at the end of the day, Fubara will be recalled to become just a puppet governor, because when you remove the wings of a bird, the bird does not fly.
Now, I need you to leave us with suggestions as to what are the options for Sim Fubara, what he can do while the 6 months last to extricate himself from this web, if possible.
You mean what Fubara will do?
Yes, his options, legal or otherwise.
Well, I learned that the PDP governors are planning to go to court. It is a better option than Fubara suing as a person. If the PDP governors, the PDP control states, will go to court, they have the locus, to my mind.
Okay, what is their own locus? I was going to ask you that question. Won't the court strike it out?
Their locus is that,
has there not been party of interest?
Yes, their interest is this. You can say one that they are members of the opposition, and this state of emergency is declared in an opposition state, River State. And Fubara is a member of the PDP Governors Forum. And then, but most importantly, the governor has an interest where it concerns a breach or perceived breach of constitution. We call it public interest litigation. In fact, you can argue that even ordinary citizens of Nigeria can contend that the constitution of Nigeria is a grand norm. And where there's a perceived breach of the constitution, or where there's unconstitutionality or illegality, that in itself endows the person with standard to sue. That is local standing. So I believe that where the PDP governors go to court, it means some states against the federal government. And then the proper court will be Supreme Court. Because the Supreme Court has original jurisdiction to entertain any dispute between the states, some states, and the federal government, or all the states and the federal government, or the federal government versus states. That is the Supreme Court has jurisdiction. And once it is the Supreme Court, it will be faster. But where it is only Fubara cannot go straight to the Supreme Court, because the Supreme Court does not entertain an action that involves an individual. So Fubara will go first to the Federal High Court. From the Federal High Court, it will go to the Court of Appeal. From the Court of Appeal, then the Supreme Court. But if it is a state, PDP state, they will sue straight. They will maintain this action direct at the Supreme Court, and the Supreme Court will have what we call original jurisdiction, not appellate jurisdiction. But if Fubara goes alone as a person, then it will be from the Federal High Court to the Court of Appeal to the Supreme Court. So the Supreme Court will entertain the action in its appellate jurisdiction. This one is a technical point, and I'm able to say this because I'm an authority, that's my area. I wrote a book called Appellate Practice and Brief Writing.
All right, thank you very much. It's been a pleasure talking with you, Chief Tom Anyafulude, Editor-in-Chief, Judgments of the Supreme Court Reports. Thank you again for being with us on this segment of Signature Evening.
Thank you, because you forgot that I'm also an Ikenga.
Ikenga, it's been a pleasure. And someday we will invite you to speak as an Ikenga.
Signature TV. News in your pocket.